Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Welcome back to Talk Law Radio. I'm Todd Marquardt, helping you discover your legal issue blind spots by listening to me talk about the law on the radio. We've been talking about the First Amendment, your freedom of speech. Should laws like the Colorado law compel us to do things? I'm very passionate about this subject because I value my liberty and my freedom, and I don't want to be compelled by the government to do things. Now, the government is going to say they have a compelling interest in preventing discrimination. But at what cost? Remember, in the first part of our show, I talked about what it would take to make an exception to a constitutional right, to allow for your constitutional right to be discriminated against, to be violated. First, the government has to have compelling interest, and the procedure, policy, or law has to be narrowly tailored to achieving that interest, and courts will strictly scrutinize the law, policy, or procedure. And so what Colorado has done is said that if you own a business, you cannot discriminate against your buyers. And this lady who owns 303 Creative LLC wanted to establish a graphic design and website for weddings that she thought were appropriate, and didn't want to do that service for weddings that she didn't agree with. And so the district court denied her petition for an injunction to stop the state of Colorado from enforcing that law and penalizing her for refusing to do wedding websites for weddings that were not between one man and one woman. And she appealed to the 10th Circuit Court, and the court acknowledged that Mrs. Smith's planned wedding website qualified as speech, pure speech, protected by the First Amendment. As a result, the court reasoned Colorado had to satisfy strict scrutiny before compelling speech from her that she did not wish to create. Under that standard, the court said the state had to show both that forcing Ms. Smith to create speech would serve a compelling government interest, and that no less restrictive alternative exists to secure that interest. And the 10th Circuit agreed with the district court. They denied that her First Amendment right had been violated inappropriately. But there was a dissenting judge. The chief judge, Tim Kovich, dissented. He observed that ensuring access to a particular person's voice, expression, or artistic talent has never qualified as a compelling state interest. He said that the court should not depart from the precedents that have already gone before. He said if this continues, this approach would permit the government to regulate the message communicated by all artists, a result he called unprecedented. So this is the hidden legal issue blind spot that we need to watch out for. As business owners, as artists, we have to watch out for the municipal, state, and federal lawmakers trying to create laws that are going to infringe on our rights, that are going to compel us to run our business in a certain way. We don't want that. And so if a law is proposed that does this, please call your city council, your mayor, your state legislators, and your congressmen and senators and tell them you do not want them to pass that law. If we don't speak out, then others that do want these laws to be passed, that do believe that preventing discrimination is a stronger interest than our constitutional rights, they will win. But if you want to keep your liberty and your freedom, then you need to fight for it. by calling your legislators and letting them know how you feel. Artists and business owners alike should pay attention to the laws being proposed by municipal, state, and federal lawmakers. Artists and business owners should ask whether proposed laws with the goal of anti-discrimination increase liberty or freedom, or whether the proposed laws increase the power of the government to dictate the art you create or the way you run your business. So part of the court's discussion in this case was the type of product that she was making and whether she was discriminating against people that didn't have the same views as her, or whether she would offer services to everybody. And the parties to this lawsuit at the district court level stipulated to certain facts. 1, Ms. Smith was willing to work with all people, regardless of classifications such as race, creed, sexual orientation, and gender, and she would gladly create custom graphics and websites for them of any sexual orientation. But she would not produce content that contradicted biblical truth, regardless of who orders it. So she's willing to work with all people, but she's not willing to work with all content. So you can see that there's a difference there, right? She would produce content that she believed in for all people, regardless of their behavior, but she didn't want to create content that she didn't believe with. And she said she believed that marriage was a union between one man and one woman. All of the graphic and website design services that she provides were expressive. The websites and graphics she designed were original, customized creations that contributed to the overall messages that her business conveys through the websites. And so that's the distinction that she wanted to make, that she wasn't discriminating against people, she was discriminating against content that she didn't believe in. And so the government tried to say that her product, the creation of those websites or the creation of those designs, was just a product like a basket of apples that you could buy from anybody. But this court, the Supreme Court, said no, she does not seek to sell an ordinary commercial good, but intends to create customized and tailored expressive speech for each couple to celebrate and promote the couple's wedding and unique love story. Ms. Smith offers her speech for pay, and this was another argument of the government that because she was selling her services, it wasn't anything special. But this Supreme Court said that many of the world's great works of literature and art were created with an expectation of compensation, and speakers do not shed their First Amendment protections by employing the corporate form to disseminate their speech. So she gladly conducted business with those having protected characteristics, so long as the custom graphics and websites she is asked to create do not violate her beliefs. Abiding the Constitution's commitment to the freedom of speech means we will encounter ideas that are misguided or even hurtful. So if you don't like Mrs. Smith because she doesn't want to create those types of graphics, you have the right to say so. Nobody's going to stop you from your speech. And likewise, there are hate groups out there, and they have the right to say things in hatred. The only thing that you can't do is speak words that represent a clear and present danger. So back in 1919, the United States Supreme Court had to rule on the limits of free speech. This is the case of Schenck versus the United States. And the question was whether somebody could say something that caused others to be in danger. And the most famous example of this is you can't yell fire in a crowded theater, unless, of course, there is an actual fire, and then you might want to tell somebody about it. But that's the lesson that we learned from this, is that there is a limit to free speech if you're causing a clear and present danger. We'll have to review that case some other time, but I did want to mention it before we run out of time. Oh, there was another case in Colorado. You might remember it, the wedding cake case. So what I thought of when I was reminded about the wedding cake case is that Colorado is very aggressively trying to discourage discrimination. And I remembered learning about Adam Smith and the invisible hand of self-interest. Well, if you have a business that discriminates, they're not going to get money from the people that they're discriminating against. And so it might be harder for them to succeed as a business. And they might go out of business. So if there's more people seeking those services that don't want to be discriminated against, then they're going to win in the free market. Free market capitalism and freedom go together. They both contain the four-letter word free, F-R-E-E, freedom, free markets. And so that seems to be the hidden legal issue here. I just want to repeat that again, because I run a business. I don't want the government telling me what to do. I don't want the government telling you what to do. But if society, our neighbors, our community has preferences about businesses that don't discriminate, they're going to win. If society and the community around us has preferences that disfavor a certain group, that's unfortunate. But freedom, I think, is the principle, the value that we want to uphold, even if some mistakes are made. So I wanted to thank you for joining me on this edition of Talk Law Radio. I've had an excellent time talking to you about these Supreme Court cases, especially the 14th Amendment, the Civil Rights Act, and also the First Amendment. Sorry we didn't get to all the Supreme Court cases, but we'll get to them soon. And I want to remind you that we have a new bonus episode that'll be airing probably next week. You'll want to listen for it on Sunday at 4:30 in the afternoon or on podcasts everywhere. Talk to you later.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Each week, attorney Todd Marquardt talks about the law. His mission with the Talk Law Radio show and podcast is to help you discover your legal issue blind spots. In the beginning, God had one law. Don't eat from the fruit of that tree. Then came the 10 Commandments. Now we have federal, state, and municipal lawmakers that won't stop creating new laws. Laws that might impact you without you knowing it. Listen to the show and drop a line on Facebook or email host@talklawradio.com and let the host know what you think of the show, the topics you want to hear, and whether you want to be a guest.